Hello, everybody. This is Jeff Beaumont. I have the pleasure to present on the GRF Trust. As you know, I am a legal counsel for United Laguna Woods Village. I'm a senior partner of the law firm Beaumont Tashin. Our firm has been representing homeowners associations of all types for over 40 years. I've been doing it for 20 years, and it's my pleasure to do this, hopefully from the comfort of your home, especially during this very difficult time. And with that, I hope first and foremost, each of you are healthy and safe at home. And I look forward to spending time with you going through this presentation. And as far as the presentation goes, I want to explain it's intended to be a two-step approach. Step one would be us going through this presentation now through this PowerPoint. And then step two would be to schedule a go-to meeting, at which point we can ask questions of me and anybody else and engage in dialogue and go through your questions and notes that you may take during this presentation. And with respect to that, I recommend that each of you have available at your fingertips during this the step two of the questions and answers phase, a copy of this PowerPoint presentation. Because I think what would be most efficient is during the presentation that you're going to view now with me, next to each slide I go through, I would imagine you're going to have notes of any questions or comments. It'd be helpful to take those to step two, and when we have the live meeting on go-to meeting, you'll have your questions available to have those readily available to ask during that step two phase. So with that, I would like to go forward with this presentation. It'd be my honor. And what this is about the GRF Trust, what it says, what it doesn't say, and what it means. I'd like to first thank Bunny Carpenter for spearheading this from GRF. I appreciate her time and support, as well as Sue Margolis of United and Steve Parsons. I put together this presentation on my own, but bounced some questions off them and obtained some good information from them, as well as VMS staff, who I think as well. And I think we've got some good information to present to everybody. Like I said, it's going to be this presentation, which we're going to walk through this PowerPoint slide presentation. And then there's going to be another future meeting scheduled where we can ask and answer questions and engage in some good dialogue. So with that, let's get started and talk about the village in general. The creation of the village was a vision by the Cortese family, Ross Cortese. I'm sure everybody has heard this name. Some interesting facts. Ross is from Ohio. He was raised in Long Beach and then Glendale as well. He dropped out of high school, interestingly, and started investing in real estate and flipping. Then he had this vision of creating senior communities, active adult communities, and therein lies the creation of the three very large senior communities in California that we all now know as Laguna Woods Village, Seal Beach Leisure World, and Walnut Grove. I didn't know that Seal Beach was the first, and then Laguna Woods Village was the second, and then Walnut Grove was the third. I also didn't know that Ross then took his ideas and went out of state and continued to develop these types of active adult communities in other states. He was a pioneer and started this trend, which continues on today. With respect to the makeup of the village, I think it's helpful to look at the interested parties. Clearly, GRF is an interested party, serves two hats, two roles, which we'll get into later, that of the trustee and then of corporation that serves as the trustee of the trust and then administration of the trust. There's mutual number one that was created as the initial trustor beneficiary. And then we'll talk about how that morphed into several mutuals and then eventually ended up into three mutuals, which we have today, Third, United, and Mutual 50. Another interested party, which is interesting, is United California Bank, which is the mortgagee. This is the bank that provided the funding for the creation of the village to the Cortese family, and then the Federal Housing Administration, which we'll talk about as well. You'll notice that in the trust documents, there's a regulatory agreement that was required for the development to be completed. Let's talk now about the village's corporate structure and start with the Golden Rain Foundation Incorporated. This is the corporation that's developed to serve as an entity to help maintain facilities and services. It operates the community facilities and operates as a common interest development. The common interest development issue came up in a published court decision, which I'll go through a little bit later. But just remember, Golden Rain Foundation, Inc. is a corporation. It's an entity designed to serve two roles: to help administer the trust, as well as to actually oversee the village and the trust assets. And we'll get into those two roles a little bit later. But the Golden Rain Foundation Trust is a different, I think, concept that we have to understand. It's the trustee under the trust agreement, and it provides services and furnishes community facilities to mutuals. What's interesting, I think what we can do is just back up, and now let's try to reconcile these two concepts. Number one, the trustee, if you think about it, under any trust could be any individual. Let's say it's me, and I'm the trustee of a trust. And my responsibility, which we'll get into later as far as the duties of a trustee, is to administer that trust. Now, if I do that on my own, then I am the trustee. If I create a corporation and that corporation is named as the trustee, well, then that corporation would be the entity and the responsible party to administer that trust. And that's why we have here Golden Rain Foundation, Inc., which is the entity responsible to serve as a trustee and to administer that trust. All right, now let's talk about the corporation. The corporation is the California Corporation. It's formed through the Secretary of State, like every corporation in California. It starts with Articles of Incorporation. This is the document that gives life to corporations in California. With that, from there, bylaws are created, and the bylaws, I think most commonly referred to as the Bible of a corporation. This is what provides the governance structure for any entity in California. ytFCC6 Inc. is a nonprofit common interest development. Bylaws, you'll see from September 2014, lay out for the first time that ytFCC6 is deemed on its own voluntarily a common interest development, which means that it's subject to various laws under the Davis-Sterling Act. Now, I'd like to just remind you, we're going to talk more about that in a published court decision that came out of Leisure World Seal Beach. Also, and lastly, just remember that Golden Rain Foundation, Inc. is not a managing agent for the mutuals. Okay, now, moving on to the legal structure of the corporation, and the case that I've been referring to. I think it's important to know that this exists. I think there's some good lessons learned from this case, and I think it establishes some good precedents with respect to the governance of ytFCC6. This is the Franz versus Golden Rain Foundation Seal Beach case. And this case was decided by the California Court of Appeals in 2008. And this is about a group of members that banded together, spearheaded by one ytFCC member who's still in the community, Carol Franz, to file small claims actions, several against ytFCC, after ytFCC declined to provide various documents pursuant to the Davis-Sterling Act. We all know that the Davis-Sterling Act guarantees the access by members to certain records belonging to the entity. And here it was ytFCC. And in the Davis-Sterling Act, it lists what records members are entitled to. ytFCC took the position that they're not subject to the Davis-Sterling Act, and their members were not entitled to these records. The Small Claims Court determined that GIRF wrongfully withheld the documents and awarded damages for each violation. So each denial GIRF issued to a member, the Small Claims Court issued a monetary amount to be awarded to that member. In response, GIRF filed a superior court lawsuit for declaratory relief, which means they put before a judge a request to deem GIRF not a common interest development and not subject to the Davis-Sterling Act. GIRF's position was that GIRF is a managing agent. Remember, Seal Beach, GIRF manages and serves as a managing agent of the mutuals. So GIRF said, we're not a common interest development, we're just a managing agent of the mutuals. GIRF also said that we don't have CC&Rs, recorded covenants, conditions, and restrictions. The Davis-Sterling Act says a common interest development operates under recorded covenants, conditions, and restrictions. Instead, GIRF said we have a trust agreement or declaration of trust, which is not the same as recorded CC&Rs. Well, the court was unpersuaded, and following a trial, the trial court found in favor of the GIRF defendants, or I'm sorry, the GIRF members, and then GIRF appealed to the higher courts, and the Court of Appeal affirmed the trial court's decision and said, no, GIRF is a common interest development. GIRF is subject to the Davis-Sterling Act, and in this case, GIRF was required to provide its members access to the various records that they requested. So let's go down now to the next concept here on the slide. Next point, Davis-Sterling Common Interest Development Act. And you'll see that GIRF is subject to the Act's mandates now that it's been clarified in the Franz case, which means that GIRF is subject to the same requirements that any other homeowners association is subject to in California, which stems from governance requirements, how you conduct meetings, to certain compliance requirements like insurance. Certain insurance is required to be maintained. Disclosure obligations, certain disclosures are required to be made each year, and then alternative dispute resolution requirements, and I can go on and on. Note that in the Davis-Sterling Act, there's a provision that regulates community service organizations, which includes transfers fees. What is significant, and I'll get into this towards the end of this presentation, is that GIRF is in essence a community service organization under the Davis-Sterling Act as well, because it charges a transfer fee. Transfer fees are illegal and cannot be collected unless they're grandfathered in. And under Civil Code Section 4580, because GIRF was created before and charged a transfer fee before February 20th, 2003, it's been grandfathered into the Davis-Sterling Act, and it can continue to charge transfer fees. If there's an entity that tries to transfer or charge a transfer fee after this date, after February 2003, that transfer fee would be illegal and not able to be collected. Okay, let's go on now to Golden Rain Foundation Trust. The trust is a California trust. It's organized under the California Probate Code. And like I said previously, it operates as a community service organization as well for the village because it charges a transfer fee. Remember, any trust has trust assets, and we'll get into what those assets are and what the purpose and role and duties of the trust are with respect to the trustee, which is GIRF here. In essence, what we have here is a GIRF serving as a dual role. Remember, it's a typical corporation, and the typical corporation is regulated by statutes. We'll see there on the screen, bylaws, and through that is overseen and managed by a board of directors. With respect to GIRF's other role, its other role is that of a trustee of the trust, which is regulated by the probate code through the trust agreement for the benefit of who? the beneficiaries. And we'll talk about that in more detail in a little bit. This just gives you, I think, a little bit better idea about the big picture, which is the dual role of GRF. Okay, now we have here the what makes Laguna Woods Village unique, and that's the assets. Here, the trust assets, and you'll see that the trustee oversees those assets, and the trustor and the beneficiary gets to use and enjoy those assets. And who are the trustors and beneficiaries? Here you have United Third and Mutual 50. So this just gives you an idea of the structure of the trust and the trustee of the assets, the trustor beneficiaries, which is United Third and Mutual 50. And you'll see at the top, GRF serves as that trustee. We'll talk about this structure and what this really means with respect to GRF serving as the trustee. And you'll see that GRF as a trustee is at the top of this chart. But what's a little deceiving is the fact that the beneficiaries at the bottom are the ones that have the ultimate benefits and receive the ultimate benefits from this structure, which is managed by GRF as the trustee under this structure. So what are the trust assets? Just as a question, I think we can all come up with a good list. This is something that I think we should all remember as far as what ultimately GRF's jurisdiction is with respect to the trust assets. I think it helps keep us clear as to the dividing line between United's property, Thirds, and the Mutual 50, the towers. And with that, it's easy to just think about the clubhouses, right? The swimming pools, the golf course, the restaurants, equestrian center, and go on and on and on. So with that, does that mean because of that structure that GRF is at the top, that GRF is the super GRF that has ultimate powers like Superman? I think we all know the answer to that, but this just gives you, I think, a good idea of the purpose of GRF and its roles and responsibilities. And the answer is no. There is no super GRF, although I think GRF is super. I think United's super. I think Third and the towers. I think the village is super. But as far as authority goes, GRF does what the trust tells it to do. And we'll get into detail what that exactly means and what the sources of authority, as well as the limitations of authority, are. Remember, every organization has its limitations. Those limitations come out of the law. Those limitations come out of the bylaws. Those documents can be amended from time to time through the legislature, through the members of that organization amending their documents, like the bylaws. United, Third, Mutual 50, they have limitations as well, just like GRF has its limitations. GRF does what the trust tells it to do. Okay, what does the trust do? Well, it guarantees community administration. I think this chart isn't specifically on point, but I think it gives us a good idea as far as what that administration is and what that model is. I think community administration, when I think about what that means, I think we can all come up with our own concepts or definitions. But with that, I think there's a sense of administration of the trust assets. And with that comes costs, changes, and you'll see on this charts, quality, alignment, compliance, services. It's a system of governance. And with the system of governance and with the administration concept comes a lot of different factors. And I think GRF serving in that dual role as a corporation running and operating its own corporation, and then also that corporation serving as the trustee, has to create a system of governance to ensure that the trust assets are administered, which is important here. Remember, the administration can be delegated. And in Laguna Woods Village, the administration of the trust assets has been delegated from day one. This is different, and I'll explain in further detail later, than what we see in Seal Beach, Leisure World. In our case, in the village, administration has been delegated to VMS. GRF relies on VMS to administer various community functions. VMS serves as a managing agent. VMS takes direction from GRF's board as to the administration of the trust assets. Remember, GRF administers or directs and delegates to VMS the administration of the trust assets, which is the community facilities and services. GRF does not administer VMS. VMS is the managing agent for GRF as the trustee. And we'll talk about that, what that means in greater detail. But I think this chart is useful to see how this system of governance works and what the various factors are in that. And there's many more that we can add to this as well. Okay, what does the trust do? Well, I think we all know that it provides recreation services. What are some recreation services that you can think of? What came to my mind is fitness, billiards, cards, woodworking, swimming. There's different activities that are organized and administered. We can go on and on, but there's an extensive and ample list of recreation services that we can think of that the trust administers. What else does the trust do? Well, it ensures maintenance of trust property, from maintenance of landscaping to maintenance of streets to the community facilities, etc. The trust also protects and preserves the trust property for the benefit of the beneficiaries. GRF's primary obligation is to protect and preserve trust property, and that's number one. And that will come out of the trust agreement, and it comes out of the probate code and California law. This is for the beneficiaries, United, Third, and Mutual 50. And again, the source of the obligation of GRF to preserve trust property comes out of the trust agreement and the probate code. Okay, moving on to the duties of a trustee. I mentioned just now the source of authority that obligates GRF to preserve trust property. And I keep saying the trust agreement and probate code. Now we can go further and say published court decisions, which is also a source of authority. But for purposes of today, the primary sources of authority, both sources of authority and limitations of authority, come from the probate code and the trust agreement. With respect to the probate code, let's go through real quick and review the most applicable sections. Again, this is a short list of the applicable sections of the probate code. We can spend hours going through all the various sections of the probate code that apply to GRF's administration of the trust agreement. But let's just start, for purposes of today, with the most applicable and relevant. Section 16000 is really the foundation and starting block for the discussion of what is the obligation of a trustee. And here you can see the trustee has a duty to administer the trust according to the trust instrument. That's the trust agreement in our case. Then you'll see that section 16002A states that the trustee shall act solely in the interest of the beneficiaries. Remember that beneficiaries are the ultimate parties that are benefited by the not just the trust agreement, but the administration of the trust and the protection and preservation of the trust property. And then you'll see section 16003. If a trust has two or more beneficiaries, which we have in our case, the trustee has a duty to deal impartially. What does that mean? Well, it means that the trustee must not take action that benefits one beneficiary at the cost or expense or harm of another. And there's extensive case law that deals with the impartiality or the impartiality and conflicts of interest of a trustee serving more than one beneficiary. We have a lot of guidance on that through case law. In fact, over the years, cases have addressed disputes surrounding the management of trusts that have come from multiple beneficiaries disagreeing with how a trustee manages the trust assets. And one thing that we've learned through that case law, in fact, we learned that this through years ago, the Recreation Master Plan and the resulting lawsuit that I'll briefly explain a little bit later. The concept that just because a trustee may have the power to act doesn't mean the trustee is entitled to act if not in the beneficiary's best interest. So that concept, in essence, says that just because a trustee may have the authority or power to do something doesn't mean they're legally able to do it if it's not in the best interest of the beneficiaries. So what is the required standard of care of a trustee? And when I say standard of care, let's just think about being in a courtroom. And I'm sure several of you have served on a jury. The standard of care is what an attorney is required representing their client in court to establish for a judge or a jury to show that their clients did what they were supposed to do under the law. They met the standard of care. Well, the standard of care of the trustee, in which case, if you show that your client or you met the standard of care, then you win your case. Here, the standard of care, the general standard of care of a trustee, comes out of the concept of fiduciary duties. And trustees are required to exercise reasonable care, skill, and caution. Why is this so protected? Why is this standard so defined with respect to exercising caution? I know a lot of people out there that don't exercise caution. They actually do things before they think. They're entitled to. They're doing things on their own, or maybe it's for their own company. But in this case, the standard of care for a trustee reflects what a trustee's ultimate role is, which is to act on behalf of others, to manage property for the benefit of others, to manage money for the benefit of others, not their money, not their property, but money and property that is for the benefit of others. That's why you see this reasonable care standard that mentions skill and caution. And you'll see here good faith. And the concept is what a reasonable, prudent person in a similar position would do. There's also, you'll see in the middle of the slide here, the investment management side, which includes separate standards of care of trustees. The Uniform Prudent Investor Act, I'll get into that a little bit later in more detail. That sets forth a standard of care of trustees as to how they manage the money of a trust and assets of a trust, which ultimately is supposed to be for the purpose of the trust. The trustee is responsible for taking action that accomplishes the purpose of the trust. And lastly on the slide here, what are the remedies? What is a beneficiary left to do if a trustee is not doing their job? Well, there's, like I said, that concept earlier, which results in a lot of conflict, where a trustee does something under a trust, exercises authority that they're entitled to exercise, but it's not in the best interests of the beneficiaries. And therein lies the clause at the bottom here: existence of a power doesn't justify its exercise. And what that leads to is conflict, lawsuits, and you'll see the last point, injunctive relief. And that's a lawsuit that goes before a judge, asking the judge to please stop a trustee from doing something, or please tell the trustee to do something else. And that results in conflict. So let's just review real quick. GRF is in a fiduciary capacity, managing the money and property of the beneficiaries, managing property belonging and money belonging to others results in a higher standard of care. With respect to the remedies for breach of a standard, that results in conflict. distractions to boards. Conflict is never good for any organization, not just from a financial standpoint with unbudgeted legal fees, but from the standpoint of taking away valuable resources from those that are in a position to operate and manage the community. Okay, let's go forward with some fun facts with respect to the trust. The trust is wholly owned by the mutuals as the beneficiaries. An asset of the mutuals. GRF does not own the trust. GRF manages the trust assets, again, for the benefit of the mutuals, who are the beneficiaries. I like fun facts. I hope you do as well. And that's why I put this fun fact up regarding pizza, which you can enjoy in your own time. But there's some pretty interesting statistics here about pizza in the United States. What I did learn is that we eat quite a bit of it. All right, let's move forward with the trust. So why is there a trust? Why do we have a trust? Why don't we just have some recorded CC&Rs like every other homeowners association? Well, let's start back with the first portion of my presentation, which was the structure of the village. Remember, we talked about the FHA, Federal Housing Administration. FHA required a trust to ensure funding. Remember, the Union California Bank, which is also, you'll see in the trust documents, along with FHA, Union California Bank was a lender on this development. So Cortese went out and sought lending from Union California Bank, wanted that loan to be insured by the FHA. FHA came in and said, we'll insure that loan as long as you enter into a regulatory agreement and record that against the property. That regulatory agreement, again, was required to develop and manage the trust property. And therein lies the trust agreement. Trust agreement was recorded to identify the trust assets, which, as we previously discussed, are for the benefit of the beneficiaries. Union Bank lent money to develop the village, and FHA said, we'll insure that loan as long as you record this trust agreement, which will forever obligate GRF to manage and operate that trust for the benefit of the beneficiaries. With respect to the responsibilities of the trustee, GRF, let's talk about the trust now. And what does the trust say? I think this is a good time to go over the responsibilities with respect to the trust and to get to know the trust a little bit more. But the trust starts with operations and management. It gets into the improvements. So GRF's responsibility is to ensure that it operates and manages the improvements, that it provides administrative, recreational, and medical services. These are all terms and phrases that come directly out of the trust agreement. When you see medical services here, which is interesting, is that the FHA, during a negotiation period with the Cortese family and the bank for funding the development, wanted there to be some type of medical services provided through the trust and GRF. It's my understanding from my limited research that an agreement was reached between FHA and Cortese that GRF would not provide medical services, but instead Cortese contributed to the building of the Saddleback Medical Center to accommodate FHA's requirement. And I think the FHA wanted medical services because of the pure number of residents that this community would be overseeing and providing for. So that's pretty interesting. And then lastly, as far as the trust, everything is done for the benefit of the beneficiaries and their successors. Remember, for the benefit of the beneficiaries and their successors. So that's GRF's responsibilities under the trust. I'm going to go through just real quickly before I move on the actual trust itself. And this is not up on the screen, but I'm just going to give you a brief overview of the trust agreement, which you can all pull out. You may want to make a little note on the side here to, as a to-do, take a look at the trust agreement before we schedule our phase 2 of this presentation, where we have that live Q&A, and just walk through it real quickly. But you'll see the trust agreement starts with certain recitals, and it goes through and identifies the interested parties and the purpose of the trust. Then it gets into its actual sections. Section 1 sets forth the name of the trust. Section 2 identifies the trust assets, the trust estate, it's called. Section 3 identifies the beneficiaries, and this tracks the same format as anybody else's trust, like my trust, for example. Section 4 talks about the rights of third parties, and this is where the FHA comes in with respect to the development of Laguna Woods Village. Section 5 talks about the duties, compensation, and reimbursement of the trustee. Section 6 talks about the amendment of the trust agreement. Section 7 talks about the rights and powers of the trustee. It's all coming out of the trust agreement here. Section 8 talks about the regulation of the trustee, GRF. This is where you can change trustees, and it's reflective of the probate code. Section 9 talks about rules of how you interpret the trust agreement. These are just basic provisions in a trust. Section 10 talks about the rights of assignees. Section 11, recording the trust. And you'll see there's 2 exhibits to the trust. There's an actual legal description of the trust property in Exhibit A. In Exhibit B, you'll see that agreement between GRF and the initial trustor / beneficiary, which was Mutual One at that time. In order to create a trust, you have to have a designated beneficiary. At that time, it was just Mutual One. And then that later turned into 3 beneficiaries. Obviously, we have United, Third, and Mutual 50. And then United California Bank is part of that Exhibit B as well. So that's just an overview of the trust and what it looks like and how it's organized. So now let's get into what the trust says. So with respect to GRF's responsibilities, we talk about maintenance. This is number 1. Remember, we talked earlier about the purpose of the trust is to protect and preserve trust property. And this is the core of that, maintenance of property, maintenance of, what does maintain mean? It means to maintain improvements. It means to maintain the grounds. It means to maintain equipment in good repair. Again, what does maintenance mean? This is something that we should think further about and make sure that we have very clear structure and guidelines on what that term means, and that everybody's in agreement as to how the word maintenance is construed. With respect to the authority of the trustee, so we just came from talking about what the trust says as far as responsibilities for maintenance. Then we talk about now the authority of the trustee. Authority, let's look at that word, authority of the trustee. I ask each of you to step back right now and ask yourself, what is your definition of authority? I've asked several people that, and it's interesting to get their perspectives. Some are similar, others are very different. And I listed here a couple quotes that I think are not just interesting, but entertaining as well. But here's a quote about authority, where it says, authority and power are 2 different things. Power is the force by means of which you can obligate others to obey you. Authority is the right to direct and command, to be listened to or obeyed by others. Authority requests power. Power without authority is tyranny. That's a pretty interesting perspective. Here's one more, power versus authority. Power is the ability to do something. Authority is the right to do something. I like that. Okay, now let's talk about the trust agreement and powers. Remember, the trust agreement provides certain authority to GRF as the trustee. Remember what I talked about earlier as well. When you have certain documents, whether it's thirds documents or GRFs or Uniteds or Mutual 50, the underlying documents of those organizations not just set forth the powers of that organization, but the limitations of powers, which we'll get into as well. But here under the trust agreement, we have powers. And the trust agreement says, in addition to all powers, rights, and privileges provided by law for trustees. So what that means is that GRF has all the powers, rights, and privileges that the probate code provides trustees in the state of California. Number two, all powers necessary to carry out the duties imposed on trustee, which is GRF, by the trust agreement. So here it says GRF has all the powers necessary to accomplish the purpose of the trust. And the trustee has the sole discretion as to how it does that. Sole discretion. And that comes from the GRF board, determining how best it will serve as trustee of the trust agreement, carrying out the purpose and functions of the trust. All right, with respect to the GRF authority and the trust agreement, let's talk about other powers listed in the trust agreement. Specifically, the trust agreement states that GRF has the authority to establish rules and regulations. Well, this is very different if you think about it. The typical trustee of a trust operates and manages that trust to preserve and protect the trust assets for the benefit of beneficiaries. Now we're talking about a trust agreement that goes further, that gives a trustee the authority to regulate people, not property. So here you have the power to establish rules and regulations in GRF's sole discretion relative to the use of the community facilities and the extent of service to be provided in connection with them. So what is interesting is that through the physical property side of this, GRF is responsible to maintain the trust assets. It's also responsible to adopt the rules and regulations necessary to protect the community facilities and the trust assets through the regulation of conduct of the users. This is very unique and unusual in the context of a trustee operating and administering a trust in California. Also within GRF's authority under the trust agreement is the fiscal side of administering a trust. So with respect to fiscal control, you'll see here that GRF at its sole discretion shall refund credit to the members of the cooperatives a proportionate share of sums in excess of the amount expended after each fiscal year. I've done a little research, and this provision is in the trust agreement for not just GRF and Laguna Woods Village, but Leisure World as well as Walnut Creek. And here you have the concept of what does refund and credit mean? Well, I think we all know that just from years of operating, GRF creates a budget, and this budget allows for the crediting to the mutuals or beneficiaries if there's any excess at the end of a fiscal year to apply it to the next year's budget. But this language comes right out of the trust, and it also pertains to the Prudent Investor Act, which comes out of the probate code. The Prudent Investor Act, I mentioned earlier, creates a standard of care for trustees managing trust assets, and particularly the money side of a trust. The Prudent Investor Act is a standard of care that defines what a trustee can and cannot do when investing the money of others as a trustee. It creates a reasonableness standard, and it says that the trustee shall act like a reasonably prudent investor would act in similar circumstances. It requires trust sums to be used to accomplish the purpose of the trust in light of the trust assets as a whole. So What that requires is a trustee to look at liquidity first, safety second, and return last. And that requires an approach where the trustee is looking at the trust assets as a whole, thinking about how best to manage those assets to accomplish the purpose of the trust. There's no black and white rule what a trustee can and can't do, but whatever actions it does take with respect to managing the trust funds, those management decisions shall be made looking at the trust assets as a whole, keeping in mind liquidity, safety, and then return last. And that's the Prudent Investor Act that comes out of the Corporations Code, which is a helpful guide to helping a trustee engage in fiscal management. So with respect to GRF's authority and liability, just know that the trust agreement contains provisions that provide limited liability with respect to GRF's actions as trustee. It states that with respect to all its actions in carrying out the purpose of the trust, the trustee shall have no liability. There's an exception, which is an exception that we see a lot in other trust agreements, and it applies to willful or wrongful misconduct. So even though a trustee is protected from liability with respect to their decisions, and if you think about the purpose of that protection, if that protection didn't exist, beneficiaries would be suing trustees and consuming the courts because they didn't like what a trustee may have done with the trust assets. They didn't care for the investment they made. They didn't care for how they maintained or repaired property. Trustees are protected from claims like that. However, if a trustee acts with willful or wrongful misconduct, then they're exposed to liability. And that's the protections afforded on the trust agreement as well as the probate code. All right, let's move on now to a different topic of discussion, which is similar to the trust agreement, because I think now they interrelate with one another, but it has to do with the GRF bylaws. If you recall, earlier on, I talked about the structure of GRF, and I spoke about the trust agreement. I also spoke about the bylaws. The GRF bylaws have been amended from time to time. If you go back in records, you'll see that in 1969, the GRF bylaws were created. And then from 1969 to 2002, they were. I didn't get that. They were. Let me turn my phone off here. From 1969 to 2002, they were then amended for the first time, and that's when, with respect to being amended for the first time, that's when Section 2.1.4 through 2.1.7 came into play. And that's the first time where there was a movement to regulate how GRF conducted itself under the trust agreement through the GRF bylaws. That's significant because what we saw before 2002 was there were other amendments to the bylaws, but for the most part, the trust agreement applied to the GRF and the trust, and the GRF bylaws applied to GRF as a corporation and how that corporation conducted itself. So with this movement starting in 2002 going forward, we saw GRF taking actions to administer the trust that started to call into question how it was doing that and whether that was in the best interest of the beneficiaries. There was, as you recall, I mentioned the Recreation Master Plan came into play, and that resulted in conflict and litigation, and that resulted in further amendments to the trust agreement and the bylaws. The Recreation Master Plan, in short, was a plan adopted by a previous GRF board for the use of approximately $10 million in GRF reserves and to obtain approximately a $10 million loan to pursue a plan to restructure, remodel, improve a lot of the trust assets and facilities. The mutuals felt at that time that the plan did not reflect the true desires, needs, wants, interests of the beneficiaries, which was United Third and Mutual 50. And through United's efforts in taking the lead, filed a lawsuit at that time against Golden Rain Foundation, GRF, challenging that plan, which ultimately resulted in a settlement. The settlement was put into place, and that resulted in a agreement where the bylaws and trust agreement were amended. And that's where we saw section 2.1.4 for the first time requiring GRF to pursue approval from the mutuals for certain limited actions before GRF took. So with respect to that amendment, and now for the first time, GRF being required to consult with the mutuals before taking certain limited actions, we now have the current structure that we're working under, which is the GRF bylaws as amended September 29, 2014. This document requires, or this amendment to the bylaws requires GRF to obtain the approval of the corporate members, which obviously we know are the directors of United Third and Mutual 50, prior to engaging in any business or activity specified in 2.1.4. So it starts with 2.1.6, and then it sets forth a standard of prior approval to obtain from the corporate members prior to engaging in any business or activity specified in paragraph 2.1.4. So let's look at 2.1.4, which says to engage in any business or activity now or hereafter permitted by law, the articles of incorporation and these bylaws. So what this 2.1.4 says is that GRF has the authority, which you're not seeing here, but this is a lead-in to say GRF has the authority to engage in any business or activity now or hereafter permitted by law, by the articles of incorporation and these bylaws. So GRF can do anything allowed under the law, articles, or the bylaws. However, subject to the terms of the trust and subject to the limitations as follows. So here are the limitations that were agreed upon following the lawsuit filed by United, resulting from the Recreation Master Plan, where GRF, United, Third, and the Towers, through a vote of the corporate members, agreed to the following changes. Here we have in 2.1.4 a limitation number 1. And this is the first limitation that triggers GRF to go to the corporate members to obtain their vote of approval before going forward with number 1, the sale and or conveyance of Golden Rain Foundation, GRF, or GRF trust property, real estate and or improvements. So the sale or conveyance of any real estate or improvements, or the value of the real estate or improvements is appraised for at least $500,000. At least $500,000. So any sale or conveyance, that's number 1, would have to be approved by the corporate members. Number 2, as to any lease of real estate or improvement in excess of 1 year. So any lease in excess of 1 year would have to be approved by the corporate members. With respect to number 3, as to any acquisition of real estate, where the total amount to be paid is at least $500,000. And that's number 3. Number 4, we have as to any expansion of facilities or construction of new facilities. So we have to look at the words expansion of facilities or construction of new facilities. In addition to an existing facility of at least 1,000 new or additional square feet. And this is where we get into the definitions here. So what do we mean by the expansion of facilities or construction of new facilities? What type of expansion and what type of construction triggers this corporate member vote? Well, the addition has to be to an existing facility of at least 1,000 new or additional square feet, or a minimum cost of $500,000. So the expansion of 1,000 new or additional square feet, so a new structure that is 1,000 or more square feet, or in addition to an existing structure that is 1,000 or more square feet. Or the cost, the minimum cost is $500,000. Well, what does cost mean? Where does that $500,000 start and stop? We'll talk about that a little later. That's number 4, the 4th limitation. So let's go to the 5th now, which is pertaining to the borrowing of money. And this limitation requires GRF to obtain the approval excuse me, of the corporate members prior to borrowing any money in excess of $1 million. Now, 2.1.4 applies to GRF actions. Again, what GRF actions does this apply to? All GRF actions? No. This is a limitation of authority imposed by the beneficiaries through the bylaws and amendment to the trust agreement that only apply to 5 specific actions: the sale of property, the leasing of property, the purchase of property, the expansion of property, and obtaining loans. This gives the mutuals limited oversight, which means we have to have realistic expectations as to how involved the beneficiaries are with respect to GRF's ability to administer the trust assets. If you recall early on, under the probate code and the trust agreement before this change, trustees are given discretion as to how to administer that trust and the trust assets, which has to be obviously for the best interest of the beneficiaries, but how that's done lies solely within the discretion of GRF. The limited oversight that we're now seeing with the beneficiaries getting involved in those decisions and giving GRF the authority to go forward with those actions now apply to these 5 topics. Again, regarding the sale of property, leasing, purchase, expansion, and obtaining loans. What we need to focus on is how best to strike that balance between what the expectations are of the mutuals with respect to GRF's actions and GRF's ability to manage the trust assets efficiently as it's responsible to do, making sure it is doing what it feels it's best for the beneficiaries and hopefully meeting the needs and requirements of those beneficiaries. Having realistic expectations prevents conflict. Conflict comes out of situations where there's differing interpretations. Conflict results in unbudgeted legal fees. Conflict results in litigation, which is not good for any organization. We also have to think about efficiency. We want to make sure that if any of these 5 actions are contemplated by GRF, there's clear guidelines as to what those actions are and when a vote of the corporate members may be required. Leaving people guessing may result in inefficiency by the calling of corporate member meetings unnecessarily, because if you remember, these actions cannot be taken by GRF unless there's a corporate member meeting, which takes time and energy and staff's time to facilitate and conduct. and time is money, and efficiency is very, very important with respect to the operation and management of the village. Okay, let's go forward now with our new system of governance. With respect to our new system of governance, we have VMS and self-management. And to review, we all understand and remember that PCM previously managed the village and served as the managing agent. Did any of you know that from day one, Laguna Woods Village has always had a managing agent? I learned that preparing for this presentation. I was quite surprised. At day one, because of the lending through the bank and the FHA's involvement to ensure that loan, FHA required the village to be managed by professional management. And the village has had 3 managing agents. The first managing agent was Leisure World Foundation. And I think from my limited research, Leisure World Foundation was an entity that was created by the Cortese family as a stopgap between getting funding and getting the development in progress and started and off the ground to when they could finally hire an outside professional management company. Because if you look at the documents from early on, there were discussions in agreement with the second managing agent, which was PCM, Professional Community Management. And FHA had to approve PCM as the managing agent, and that took time. So until that approval came in, Leisure World Foundation was created and served as a managing agent. Then PCM came in, approved by FHA, and then PCM was then terminated and replaced by VMS, which is a system of self-management. When I say self-management, what does that mean? Well, VMS is a organization. It's a corporation, and like every corporation has members. GRF has members. All of the residents, all of the members of GRF are also members of the mutuals. Third has its own members. Third's members are owners of condos within their community. United has its members. United's members are its shareholders. VMS has members. You'll see here on the screen, VMS members are GRF, United, and Third. Remember, VMS has its own board of directors. GRF, United, and Third own VMS. They're the members, but VMS is managed by a board of directors. The board of directors of VMS are appointed by GRF, United, and Third. Each appoint 2 representatives, and those representatives make up the board of directors, and the board of directors of VMS manage VMS. GRF doesn't manage VMS, United doesn't manage VMS, and Third doesn't manage VMS. Now, the representatives appointed by GRF, Third, and United reflect, obviously, the sentiments, views, and ideas of each of them. And with GRF, United, and Third staying connected with its representatives and working with the VMS board, there is an intended level of cooperation, synergy, and teamwork to accomplish the purpose of VMS, which was to serve as managing agent, giving the mutuals more control into how the village is managed with respect to the overall purpose and function of not just the trust agreement, but the needs and requirements and desires of each of the mutuals, as well as via GRF. And so this governance model that we've created is a self-management model, where again, VMS is the managing agent, but owned by the mutuals, who appoint members, their respective members, to a board, and that board manages and oversees that new system of governance. With respect to VMS Inc., like I said, it's operated and managed by a board of directors. Specifically, that board then, like any board that we're accustomed to, the GRF board, the United board, third board, that VMS board hires a paid CEO. That CEO hires staff and oversees that staff. VMS as a managing agent is a managing agent for GRF, United, and Third. VMS as a managing agent for GRF, United, and Third take direction from GRF, United, or Third. GRF, United, or Third, under managing agreements, give direction to VMS as to how VMS manages their particular assets, their particular communities. In GRF, it's a trust assets. United, it's its physical property. And Third, it's its physical property. VMS directors implement direction from GRF, United, and Third. Again, this is where the value of this model of new governance and self-management comes out of. When the village was managed by an outside professional company like PCM, the mutuals in GRF did not have any type of ownership interest in PCM, didn't have any ability to control who served on the board of directors for PCM, and did not have the ability to help direct and guide PCM. GRF, United, and Third, you'll see at the bottom of this slide, manage their own affairs, but using VMS as their managing agent. So what are some differences between VMS's affairs and the mutual affairs? That's been a question I've heard asked from time to time. And I think the easiest example that we can come up with, at least I can come up with, was, what's the difference between VMS's affairs and, let's say, United's affairs? Well, VMS's affairs vary, I think, significantly. Number one, VMS has to manage employees. VMS has to determine how it manages employees, time off, benefits, pay. That is not a function of United. It's not a function of Third. It's not a function of GRF. What's another example of something that VMS manages and addresses that the mutuals or GRF doesn't? Maybe purchasing, for example. I know that's come up before. Purchasing is something that VMS does, and how that's done, I believe VMS dictates that. Now, with respect to the mutuals, what are some things that the mutuals do that VMS does not do? Well, the mutuals, through their boards, adopt rules and regulations. The mutuals, through their boards, as well as VMS, not just adopt the rules and regulations, but how to enforce those rules and regulations. That's then delegated to VMS through specific delegation. And VMS is tasked with the responsibility to taking the policies and procedures and rules that United, Third, and GRF create and adopt, and VMS carries out those functions, which is different from VMS carrying out and adopting certain policies and procedures with respect to its employees, with respect to maybe purchasing. Now, that doesn't mean Third, United, and GRF cannot, through its relationships, through its working time, through its communications with the VMS board, work with the VMS board to explore how maybe VMS can do purchasing differently, how VMS may approach certain issues with employees or labor differently. And that's where the control mechanism comes in, and that's where the self-management value and benefits comes in, which you cannot see through an outside company serving as managing agent, because an outside company serving as a managing agent would not engage their clients on that level and allow their clients to dictate what can or can't be done, or what should or shouldn't be done with respect to their labor and employees purchasing and things of that nature. Okay, lastly, what happens if the trust were to terminate? We all know that we worked hard to amend the trust to extend its term. Right now, with the extension of the trust, which we all worked hard to do and the corporate members approved, the trust will not terminate until March 2nd, 2044. In California, there's law that says trust, recorded documents, etc., expire after a certain period of time. And so with that, we looked at the trust agreement and decided that it would be best to ensure that we had an amendment in place sooner rather than later to see that it's extended out as far as possible. And that's where we came up with the March 2nd, 2044 date, which was the furthest time we could extend the trust under California law. With respect to the trust agreement, if it were to terminate, just real quickly, we have to follow certain laws. GRF has to provide an accounting to the beneficiaries. There has to be a distribution of the trust to estate, subject to any debts or other obligations. Obviously, the trust estate are the community facilities. So how do you divide that up amongst Third or United or Mutual 50? Again, the trust termination would create significant, very difficult issues, but these are things that the probate code provides, just so everybody knows what to expect. The beneficiaries, in the form of undivided interest, proportionate to the respective trustee sums. That's what the trust estate consists of, and each mutual has within the trust agreement a certain percentage allotted to them with respect to what their interest is in the trust assets. So if this were to be divided amongst the mutuals, it would be divided amongst the mutuals according to their percentage interest in the trust estate. United has the largest, then Third, and then the Towers. And it's right here, 58.5%, Third has 39.2%, Mutual 50 has 2.3%. Now, significantly, with respect to the termination of the trust, obviously by this structure and framework that's required under the probate code as far as the division of trust assets, this just would not work and it would be devastating. But also what's interesting is that if the trust agreement were to terminate under the Davis-Sterling Act, GRF would no longer be legally entitled to charge a transfer fee because it would no longer be grandfathered into that exception. So I think that's really interesting as well, because we rely so heavily on that transfer fee to fund the budget to maintain and preserve the trust assets. Okay, with that, we've reached the end of the presentation, and we are now going to schedule phase 2 or step 2 of this, where we're going to schedule a separate meeting at which we can go through your questions that you may have come up with during this presentation and have a good dialogue as to not just your questions, but answers, and maybe some discussion about what types of areas we want to spend more time on, all boards, and go from there. So thank you for your time. Thank you for the opportunity. And I hope everybody stays healthy and safe at home. Goodbye.